Good day and welcome to another episode of Strictly Legal on WESN Content Capital. I am your host, Rondell Donawa, attorney at law. And of course, you can stream us at WESN CC on all social media platforms, including the World Wide Web. I'm happy once again to bring the law and you. And today we are speaking about the Tobago Autonomy Bills. 2020-2021. And of course, let me just give you some context before I introduce my guest for today who is joining us via the web. The Constitution Amendment Tobago Self-Government Bill 2020 and the Tobago Island Administration Bill 2021 propose to accord self-government to Tobago and to provide for the powers and functions of Tobago Island government and Tobago legislature. Now, the Constitution Amendment Tobago Self-Government Bill 2020 was introduced and read a first time in the House of Representatives on October 14, 2020, pursuant to resolutions of the House of Representatives and Senate on November 9, 2020 and November 17, 2020, respectively. A joint select committee was appointed to consider and report on the said bill. Now, there were a lot of publications of the draft proposals and call for public comments. And on April 17, 2021, the JSE published its draft legislative proposals and electronically and manually issued call for comments. So these, there were electronic copies of the drafts that were posted on Parliament website, Facebook, other media, video productions explaining the details of the proposals and inviting comments from persons within the fraternity, meaning Trinidad and Tobago, of course, as well as copies of these of this proposal was sent and distributed nationwide. There were also public consultations done, public surveys, as well as feedback from the general public, which was submitted through April 17th to May 2021. Now, these bills recently were debated in the House of Representatives on the 28th of June 2001, straight through to the 30th of June 2021. However, due to the lack of opposition support, the bill was returned to the Joint Select Committee stage and a resumption of public consultation begun. Now, I believe these public consultations will span a period of 2 weeks or so to invite more comments as to the bill because, of course, the opposition would have stated that there need to be more consultation, although in the JSC report there were numerous consultations on the bill as well as persons who would have been called to comment. Now, my guest this morning is Mr. Christopher B A George, attorney at law. Now, he's a barrister that was called to the Bar of England and Wales in 2017 and admitted to practice in Trinidad and Tobago the following year. Now, before his foray into the legal profession, Mr. George worked in the oil and gas industry for more than 10 years. Engineer with a degree in chemical and biomolecular engineering. His work is focused on ensuring that clients understand the risk of litigation. Now, he generally delivers opinions for clients before and he engaged in disputes in the court. Mr. George has attended or completed many trials in magistrate and civil high court. He has also appeared as counsel in the Court of Appeal. Now, Mr. George is also a national judo champion of Trinidad and Tobago, and he is a judo Olympian in the 2016 Rio Olympics. So we have an attorney at law, we have an engineer, and we have Olympic alumni as my guest today, a man of many traits. So good morning, Christopher.
Hi, good morning, sir. How are you doing?
I am well, and thank you for joining us on WESN Capital to talk about the Tobago Autonomy Bills.
Yes.
No,
firstly, yes, go ahead. Firstly, I want to thank you for inviting me on the show here, Strictly Legal, and I hope that I can be of some assistance to you in maybe expanding the conversation And I hope it doesn't become too contentious.
Of course, I mean,
circumstances, but I hope that I can assist. Yes.
I'm sure you will. Of course, this is a contentious matter, but of course, we're dealing with the law and dealing with practical approaches to this particular bill, particularly as we are one republic, Trinidad and Tobago and Trinidad. So let's start. The historical background with respect to how we became a unitary state.
So I do believe that that it was 1897 when Tobago became what is described as, and these are not my words, as a ward of Trinidad. Tobago had been suffering throughout that period of time with some economic woes, and I believe the British government thought it prudent to attach Tobago to a larger island because of the economic situation at that point in time. Obviously, Trinidad and Tobago's history had been intertwined from that point. And because of, I do believe, the similarities in the cultures of Trinidad and Tobago, we forged ahead until 1962 when we became an independent nation, Trinidad and Tobago, and then 1976 when we became the Republic of Trinidad and Tobago. So Trinidad and Tobago was an experiment that I believe for more than 100 years has been proved to be something that was powerful, and both of our histories are joint deeply together, where it is that we've had leaders from both Trinidad and Tobago. Our current Prime Minister obviously is Tobagonian. So I do believe that that's something that's powerful. Particularly with the legislation of how Tobago has become autonomous. That is a different story since 1976. So
and let's touch on the what became of Tobago in terms of legislation, etc.
Yes. So legislation has been interesting. I mean, since 1976, there has been talk about Tobago having some greater autonomy with respect to decisions made about Tobago. So firstly, we have the THA, or the Tobago House of Assemblies Act of 1980. And then subsequently, we have the 1996 Act, where I think that it is quite relevant here that, especially in 1996, I remember reading the Hansard of A.N.R. Robinson, where it is that he spoke about the plight of Tobagonians, and that a country, and I hope to not be misquoting him, but that a country its size has not been placed in a position as Tobago has been placed, not having effective control over its boundaries, over what's happening within the particular country. And I think that 1996 was a step forward in Tobago gaining some autonomy and therefore gaining a little bit more control over what's happened in Tobago. Since that point of time, I do think that the issue has been conflated a bit, because what I believe was recognized by a lot of individuals was that we needed a constitutional amendment to effectively give Tobago the highest form of, I believe, self-determination.
Self-determination, yes.
That's a term that comes up continuously, and that's entrenched in our Constitution of Trinidad and Tobago. And I think that principle, that idea, has been mirrored in various versions of this constitutional amendment bill.
And Christopher, if I may, what is self-determination in this respect?
So it's interesting. There are several concepts of self-determination. In my research, I lean on some of the definitions, and I would bring inside here a definition, particularly from Germany, because I think that it quite. Let me go and find it particularly, so I don't misquote this particular concept, because I think it's extremely important in the idea of how it is that we define ourselves. So Germany, as the economic powerhouse of Europe, has described self-determination as an internal and external exercise.
Yes.
Internal self-determination means enjoying a degree of autonomy inside a larger entity, not leaving it altogether, but as a rule, deciding issues of local relevance on a local level, rather external self-determination means the right of a group freely to determine its own political and constitutional status on the international level. So in my mind, we see a parallel here in what's actually happening. We have two different concepts, two peculiar concepts, one of internal self-determination and the other of external. Yes. What we're talking about with respect to Tobago, in my mind, is the internal self-determination. Yes. And
this internal self-determination, has that been achieved under the current Tobago House of Assembly Act?
I believe that it's partial. Every single thing are incremental steps. So does Tobago have better self-determination than it had in 1979? Yes. Does it have greater autonomy after 1996? Yes. But obviously, our brothers and sisters in Tobago, and we are all, as a sovereign nation, we have that connection with Tobago. As an island, I do believe that they have meritorious arguments of why particularly they need greater authority in where it is that they go as a country. So some of them are economic, some of them are investment, some of them are educational. And I do believe that taking those things into consideration, one of the things that would be prudent is giving Tobagonians, people on the ground, some sort of authority in these circumstances to determine where they're going in particular areas.
Okay, so let's now join the discussion of the Constitution, the Constitution Amendment Self-Government Bill that is presently before the House. Can you just provide some context as to what exactly that bill is and what it hopes to achieve?
So the Constitutional Amendment Tobago Self-Government Bill, I think, has various pieces. Yes. I believe in 2008 they had a version. In 2013 they had a version. 2016 they had another version. 2018 there is a version, and then again 2020 there's a version. Currently there's a revised bill of 2021. Each one is trying to develop this idea of self-governance within Trinidad and Tobago. Now, particularly the 2020 bill, the bill was sent to Joint Select Committee in March of 2018. And what came out of that, as you spoke quite eloquently about, was that in October, there was some discussions in the House of, in Parliament. Now, again, this revised bill talks about several areas, and I would speak quite particularly, and maybe we could go more in depth into maybe one of them. Fundamental principles of and purpose of the nature of Tobago self-government. That is primarily how in either a unicameral or bicameral system, Tobago would legislate and control certain issues relevant particularly to Tobago. The definition of Tobago, the division of powers between Trinidad and Tobago, the autonomy structure, the Tobago legislature, and the Tobago Island government, the civil service arrangements for Tobago, intergovernmental fiscal relations, the Fiscal Review Commission, and then intergovernmental dispute resolution. So what this bill, the Constitutional Amendment Bill, which has been now changed to two separate bills on suggestion by various legal professional, legal expertise, what it tries to achieve is that framework and that coordination between Trinidad and Tobago, while understanding that we are a sovereign state, Trinidad and Tobago, but Trinidad and Tobago may want to control different policies separately.
Now let's deal first with the definition of Tobago. Now, there's been a lot of contention with respect to the maritime waters and how Tobago should determine in terms of their sea base whether or not Tobago should have. I mean, I know in the proposal 11 nautical miles, but some Tobagonians are saying that they should have more landmass or more control of the seas. What does the bill state about that?
So the bill had a suggestion. It depends on which variation, either 6 nautical miles or 11 nautical miles. Now again, commentary, which I think is actually important here, is Delano Bart, Queen's Counsel, which gave an opinion, and he drove a lot of the discussion and the amendments to this most recent revised bill, which went to Parliament, which obviously is going under different revisions right now.
Indeed.
I think that the idea of administrative control is a little bit of a catch-22. Administrative control just basically means that I have control of everything above or the water. I think that what is core to the issue in Tobago is that they want control of certain particular mineral rights. So 6 miles, 11 nautical miles, in my particular view, is a little bit of a red herring to because again, what Tobago wants in my mind or my understanding of looking at several discourses is a little bit more control with respect to the economic product of what is within those 6 to 11 nautical miles. It's not just particularly the administrative issue, because administration is we're allowed to control boats inside there, and in my view, But then, if
I may interject, but then in that same opinion, it also indicated that this now steps into international law of the seas, and that can cause conflict.
Yes, exactly. So all the opinions, the opinions of Mr. Delano Bart, Queen's Counsel, the Ambassador Gerald Thompson, and Justice Anthony Luckey, each one of them spoke about the United Nations Convention on the Law of the Seas, which I think is very important for us to understand. Every treaty that our country, our sovereign nation, has entered into is as Trinidad and Tobago. Now, there has been some discourse that the definitions of Trinidad and Tobago are, and Tobago adds considerably to the economic zone of Trinidad and Tobago. And therefore, Tobago, if it is that it was delineated in a particular way, they would be able to have a much larger share of the economic resources, particularly oil and gas. And I think that centrally, Tobagonians, because and it's true in the past, and it's an absolute truth, that Tobago has not had the level of investment that Tobago believes that it needs to have to become a tourist destination and to become a bigger player within the Caribbean. And that is an absolute meritorious argument in the circumstances of what is proportional to invest in Tobago. But I also believe that when you look at Article 2 and 49 of the United Nations or the United Nations Convention on the Law of the Seas, it creates a little bit of an issue if it is that on a constitutional basis, we're trying to delineate Trinidad and Tobago. I know that a lot of us have looked at the parallel of St. Kitts and Nevis, but we must also recognize that we are a sovereign state versus a federalist system.
And can you just explain that particular term, federal system versus the?
So a federal system means that each country is a state unto its own. It has its own legislature. It controls its own laws. And the most famous federalist system is that of the United States of America. Now, it's interesting that Ambassador Gerald Thompson did speak about different federalist systems, particularly the United States, and how they have dealt with maritime issues. So he looked particularly at Texas and Florida. And even in the United States of America, Texas and Florida have administrative and mineral rights. So that's a differentiation, and mineral rights up to, I believe, 3 to 6 nautical miles outside of their borders. But the United States of America, as a federalist system, has controls fisheries, mineral rights, etc., up to 200 miles. So that's, again, there's a little bit of a nuance there. But in my mind, and all the opinions have come to this, is that there should be a central approach. As long as we want to remain a sovereign state, Trinidad and Tobago, which I think is foundational and important to Tobagonians, we must have a central approach to some of these particular things. And that's my view on it. So I hope that I've defined federal system.
Of course, yes, definitely. Yes.
Yes.
And as we go forward with respect to the devolved powers. Let's deal with policy, or let's start with the legislator. What are the proposals in terms of the Tobago legislature? Because at the moment there's a House of Assembly.
Yes. So I believe that there was a suggestion originally to have Tobago in a bicameral system. The name slips my head, but it's basically a two system where they wanted Tobago to be represented on a parish level, and then
which will be the People's House, and then they would have
the People's House, and then a Tobago level. When it is that they had consultation with the Election and Boundaries Commission, it's like that system did not particularly work. And remember, this is actually an integrated approach. We need to understand the utility and also the functionality of some of the proposals that will be made in a statutory provision. And I do believe that the reality is that, yes, you want individual communities to have representation, but they saw an issue with that with respect to how Tobago is naturally broken apart, even in parishes. So what was suggested, and I think that it's moved forward in the TIG bill, was a unicameral system of representation.
And this unicameral system is what exactly?
The unicameral system is one house of legislature that can that functions in making laws, particularly for a country. And I do think that a parallel analogy to this is actually Scottish Parliament with the devolved structure. Scotland has been, for the last 21 years, has had a devolved parliament since 1999. And again, I think that we should look at different systems and how it is that it's functioned. One of the ideas that's happened in Scotland is that there's been a progressive step towards the definition of what that parliament is. And I almost feel that if we do move forward with this constitutional amendment bill and the second legislation, the TIG, that it would be an incremental piece, especially with respect to the TIG. So once it is, we've entrenched the constitutional provisions, the constitutional amendments, to be able to functionally, on our highest law in the land, the Constitution, the separation of Trinidad and Tobago, particularly with respect to what is Trinidad and Tobago central government versus what is Tobagonian central government, yes. Then the TIG, which is just a statutory provision, can be incrementally amended as every other act. This is fundamental to how it is that we develop laws in Trinidad and Tobago. So I do believe that we need to make a step. Obviously, it's important, the particular step that we make, but we've seen, I've talked about 2013 and 2016, but particularly with this act since March of 2018, there's been this progressive fitting in of different provisions, even so much as developing a separate act, as when there've been a suggestion, I believe, by Queen's Counsel, that maybe it is that we should put the constitutional actions or the constitutional motions in one bill, and then we put the more functional policies, aspects into a separate bill.
Because it was also noted that those functions does not necessarily have to be part of the constitutional amendment bill. Right?
Yes.
And so let's deal now with the exclusive lawmaking jurisdiction for Tobago, which was proposed in the Tobago Island Government Bill as well.
Yes.
What are that provisions? What are those provisions entail?
All right. So I don't want to misquote. I know that a lot of times that we've had it. So again, there are two schedules, and let me bring up the particular revised revised bill. It is in the GSC.
I think particularly dealt with the opportunity for Tobago to make their own laws with respect to whether it is
policing, whether it is public policy. In that situation. So the thing is that in Schedule 1 and Schedule 2 of the Tobago Island Government Bill of 2021, they have specific devolved powers and then powers that would remain within central government. So if I take you to Schedule 1 of this particular act.
Yes.
I can speak to you directly on what Tobago still has administrative power for, and what Tobago has. So bill is long, but 1 second. So particularly in Schedule 2, and the question that you asked, what are the exclusive lawmaking powers in Tobago? Some of them, and I'm not going to mention all,
Indeed,
because we have a list of 24, are issues like agricultural, plant and animal quarantine, community affairs and cooperatives, health and social services other than national pension, heritage and historical sites, housing, transport, roads and highways. And that's within Schedule 2. So what it would allow the unicameral system, if that is passed again in Tobago, is to give particular laws around those specific issues, restaurants, bars, casinos, and other similar establishments, sports. So it gives lawmaking power to issues that can affect day-to-day running of Tobago, improve, and it's actually something that I spoke about in an opinion that I did for Foundation, or we talked about in the Foundation.
Yes.
Was the economic benefits of allowing people who are closer to the ground to make particular decisions, because they understand all the dynamics. And sometimes those dynamics cannot be distinguished or talked about easily between anyone who does not live on the ground. Just as Trinbagonians, we know that matters particular to Trinidad and Tobago can be understood more easily by Trinidad and Tobago individuals.
Yes.
Just as how Tobagonians can understand things that are happening in Scarborough, in the different parishes in Tobago. And I do believe that is a powerful thing. And I would suggest that this most recent amendment does capture some of, maybe not all of the legislative powers that are required, but it does capture a lot of them in the TIG bill.
Including now the allocation, the fiscal allocation to be increased from what it is, like 3% to now 6.8%.
6.8%. And so again, there's been much discussion about that, because even before, in the THA Act, there was a discretion to actually go beyond the 4 or 5%, because sometimes it varies year to year. Now, the issue that I see is that it's fixed at 6.8%, and I believe that with consultation, they can get it as high as 8%, I believe.
Yes, right? With the intergovernment fiscal, actually there's a fiscal committee that I think is being proposed that will be headed by the Minister of Finance, etc.
Exactly. So the opinions actually speak about this, and this was so Ambassador Jared Thompson and Justice Anthony Luckey speak about this in the first variation of the Act, because the first variation of the Act in 2018 does have all these provisions within it, but what they've done is separated into two separate acts. Now, what's interesting there is that they've made a comment and they've made the parallel of St. Kitts and Nevis. If, for example, St. Kitts or Nevis wanted to, they have the power to borrow. Yes. But what international organizations would always ask for, and this is obviously the federalist system, is for the federal government or the central government to back any proposal with respect to investment and borrowing in the particular island. Because again, any fiscal measure, any borrowing measure, it will particularly affect both islands with respect to any interest rates that we get from central, the International Monetary Bank,
and as well debt, in terms of who will pay back the debt.
Exactly.
But Christopher, we are out of time. So just the closing comments in terms of whether you think that this bill will pass, whether it will work, or the amendments.
So I'm going to answer the first question
quickly. You have 30 seconds.
The last question first. The last question first is, I do think that this bill can act. I do think that it's a step. It may not be everything, but it is a step in the right direction. If it were passed, I'm not a politician, but I don't know and this is just my feeling, I don't know how to record the sentiment which is out there, because it seems that it is the battle lines have been drawn. even though I do believe that this is a nuanced approach, which we should always, a nuanced and pragmatic approach, which we should always do. So that's my view, and I'm kind of towing the line there. So I do think that this bill could work, but I'm not sure if it will pass in Parliament. Well,
let's see, because at the end of the day, it's politics as well as law. So, Christopher George OLY, thank you so much for gracing us with your presence virtually and dissecting the bill. And I do sure that the viewers will appreciate this conversation today. And thank you so much.
All right, thank you so much. All right, until next time. We have to meet in person.
Certainly. Certainly.
We have to meet in person.
Definitely.
Right, no problem.
Definitely.
All right, thank you.
Thank you.
All right.
So it's a wrap. You have been watching Strictly Legal on WESN Content Capital. I am your host, Rondell Donawa. Please be viewing next week. Have a great day. God bless.